Welcome to the Bible Forum. I'm Warren Sprouse. We've had a lot of activity this week relative to the FISA court. Intrigue, lies, misfeasance. Democrats at the highest level of government seem to be working to turn the United States into a banana republic, irrationally railing against the president and manufacturing intelligence data to bolster their claim. And you might think that's an exaggeration, and I wish it were. We have been regaled by various news outlets and elected officials about all sorts of missteps and illegalities by the Trump administration until we almost don't know what's true and what isn't. The issues surrounding the FISA court and its decision to allow law enforcement to wiretap and otherwise surveil various members of the then Trump campaign have filled the airwaves for over a year. Well, now we're learning that almost nothing of what we were told is true. The Republicans on the House Intelligence Committee released a 4-page memo demonstrating just how far afield the common opinions really are. And now the Democrats want their version to also be released. The immediate difference? Well, the Democrat letter was not vetted by the intelligence community. The sensitive issues under discussion demand that this be done. The Republicans did it. Therefore, the president sent the memo back with the instruction that it must be vetted by these folks first. And now we're being told that's a political ploy. The long and the short of it all is this. The radical left has deep-seated power and is entrenched in the federal bureaucracy. Donald Trump threatens that. Prior to the 2016 election, a former FBI agent and alleged operative of the Hillary Clinton campaign and Democrat National Committee, Christopher Steele, presented to the FBI a dossier. It was presented as proof that the Trump campaign colluded with the Russians. Now, this proof drove the FISA court to allow the Intelligence Committee to spy on, ostensibly, the Trump campaign. The information in that dossier did not appear in any FBI or CIA documents or reports. It was new news to our intelligence community, and yet they embraced it. Why? The Justice Department needed to be on board before they could obtain a quarter from the Foreign Intelligence Surveiller, or FISA's court. This court, by the way, exists only to authorize spying on foreign operatives and terrorists, not American citizens. Leadership at the DOJ knew full well Christopher Steele's political motivation and connection to both the Clinton campaign and the Democrat National Committee. He worked for them. They knew that all of this was wedded into this as the thing went to the FISA court. And yet the FISA court granted it, and the spying began. It was pointed at a former Trump associate, so wiretaps and other intelligence gathering tools scooped up information from and about Trump, an American citizen. Two terms used are misfeasance and malfeasance, both of which perhaps need some defining. Misfeasance is doing a lawful act in an unlawful manner. Malfeasance is a wrongful act by an elected official. The FISA experts, all of those former FBI and DOJ lawyers most familiar with the process, repeatedly assured us that federal procedures were in place to eliminate the possibility that unverified information would make its way into a FISA court or survive a cursory consideration by a FISA judge. These things were so bulletproof, the mere mention of such a possibility was a waste of breath. It's unheard of, they laughed. It's laughable. They couldn't have done it because it can't be done. But the House memo shows that it was done, that they did do it. They did present raw, uncorroborated intelligence and were not laughed at. They were not shot down. They got the warrant. And former Director of National Intelligence James Clapper, a California Republican, Adam Schiff, a former FBI Director, James Comey, and scores of their colleagues spent a year telling us that there's nothing to see here. Clapper admittedly had and has no idea what role the dossier played in opening the investigation because he didn't learn of the FBI investigation until March of 2017, 2 months after he left office. So he can't help in answering any of these questions. The question he can answer, however, and has answered repeatedly in scores of televised interviews, is how much the Steele dossier had been corroborated by the time he left office in January 2017. Clapper says he heard of and read the Steele dossier in December of 2016 when he was working with the intelligence community to put together his IC assessment. When asked whether any information from the Steele dossier informed the ICA, Clapper consistently gives the same answer, almost verbatim. He says they didn't have time to validate the second and third level sources in the dossier, so they didn't include that information in the ICA. When questioned further about his knowledge of anything in the dossier that had been validated prior to his departure in January of 17, he repeatedly cites 2 items. Russian President Vladimir Putin hated Hillary, and Putin wanted Trump to win. So according to the former Director of National Intelligence, none of the allegations in the dossier about volunteer Trump campaign advisor Carter Page, the subject of the FISA application, had been validated by the FBI when they were presented to the FISA court as probable cause to designate Page an agent of a foreign power. What the FISA court got was raw and unevaluated intelligence, something they are not supposed to get. The intelligence community must meet these basic thresholds in order to spy on an American citizen, which happened with Carter Page. Any person, it says, knowingly engaging in clandestine intelligence gathering activities for or on behalf of a foreign power, pursuant to the direction of the intelligence service or network of a foreign power, or knowingly engage in any clandestine intelligence activities for or on behalf of such foreign power, which activities involve or are about to involve a violation of the criminal statutes of the United States. A person who knowingly engages in sabotage or international terrorism. A person who knowingly enters the United States under a false or fraudulent identity. A person who knowingly aids or abets any person in the conduct of activities described in subparagraph A, B, or C, or knowingly conspires with any person to engage in activities described in subparagraph A, B, or C. Now keep in mind the only parts of the dossier corroborated by December 2016 were Putin's hatred of Clinton and his desire for Trump to win. And Democrats are right now having to run their version of the Intel Committee's findings through the Intelligence Committee before sharing it with the president. And yet the FBI successfully convinced the FISA court, using uncorroborated information in that very dossier, that Page was an agent of the foreign power. Now all of that has come undone. And the Democrats on the Intelligence Committee are scrambling to justify their actions. Actions which are hopefully and openly unlawful. I can't imagine what the FISA judges are saying, doing right now, having been snookered this way. And it challenges and taints the entire intelligence system of our country. But one can only wonder, will heads roll?